what a good discussion. The format, and let me just look at my bosses over here, I think is to have a few questions within the panel and then to move to general questions. Ammon, is that, Jeff, is that right? Okay. So let me start with a question for Todd. As I've explained to Todd, this is, for me, a work in progress. Whether I accept his view or not, I've reserved judgment on this, and I think that he has made a very poignant and argument, probably the best that can be made. The question about the tax, you say this is not a tax. It could be a tax, it's not a tax. And I remember when I was a kid, we had a little riddle: when is a door not a door? When it's a jar. And I was always wondering, what does it take to be a tax in your view? If it's formal, on my tax return, there are all kinds of exemptions that we're not eligible for, and then there are some exemptions we are eligible for. And so, if you look at this as saying, well, if you're not insured, you're going to have to contribute or lose a deduction, or however you want to frame it. Is that when you say doing it the right way? Would that be enough to just say you don't qualify for personal exemption, you don't qualify for various other kinds of deductions if you don't have insurance? Would that cure it in your
if it's in the form, by the way, you leave it to the professor to pick the area that I'm the least knowledgeable. I told you that I read a lot of the cases, but as my co-author read on that. But if it's in the form of a penalty, then it would be the same as, let's apply my hypothetical on voting for Democrats or voting for Republicans. No matter how you structure that, even if it's an incentive, even if you create a tax, you can't create a tax credit even. So if it's unconstitutional, then it's unconstitutional. But in my view, what Congress could probably do, and again, under the original Constitution, probably not, but under Dean John Eastman, who's in the same county as Chemerinsky, has written more persuasively on this, is that if they create tax incentives, then they can probably induce similar conduct. But this is an area that I'm uncomfortable, or that I don't know fully. If there's a tax attorney in the audience, please correct me.
I didn't mean to push you into.
No, that's all right. But I still think there has to be two conditions. One is that Congress needs to be able to do it at all. What they can clearly do is impose a general tax, a general income tax or some other kind of tax, and then incentivize the insurance industry, take over the insurance industry. That's what some people want to do. And so there are certainly some constitutional ways of doing it. With regard to the individual, I'm not as comfortable.
Well, let me then, that invites another question, of course, if you don't want to focus on the tax, and that is the necessary and proper clause, which is often deemed to be quite broad. It's often called the sweeping clause. And if the federal government wants to create a right, an entitlement, as Bill Young called it, to guaranteed issue, irrespective of pre-existing conditions, and if Congress has the authority to do that, it's an economic objective. That is a way to pay for medical care. And if it can be shown that that type of system, that benefit, has economic consequences, and that it is arguably necessary to find a revenue stream to support that, why would this not fall under necessary and proper once you assume that the federal government has authority to create a benefit, which is the guaranteed issue and no underwriting based upon pre-existing conditions?
Again, I'll take the first crack, and then maybe Bill or someone else. There's two thoughts. First of all, Chief Justice Marshall, in his prophetic, really most important opinion on this, your proper clause, says that should Congress, under the pretext of executing its powers, pass laws for the accomplishment of objects not entrusted to the national government, it would become the painful duty of this tribunal, should a case requiring such a decision come before it, to say that such an act was not the law of the land. So the necessary and proper clause may be called the sweeping clause, but it can only effectuate the underlying clause. And the second answer, I think, is that there are constitutional ends, but they still must have constitutional means. It certainly is within Congress's power to, win a war, but they probably can't order all Americans to buy war bonds or actually build tanks. Professor Richard Epstein in Chicago has published some separate papers in Wall Street Journal articles saying that there are even limits of how far the government can go to regulate insurance companies. If they do not, and this is where I'll defer to Bill, if they so regulate the insurance industry but don't allow that they become a regulated industry, then they have to do so according to the regulated industry cases, and they have to allow a proper rate of return. So if Congress, under the pretext of regulating a industry in interstate commerce, does not allow a rate of return, or try, if they can't commandeer the states under Perez, which is a case, I forget whether it was you who first cited or they can't commandeer the individual. So there are clearly some limits to what they do. They can regulate industries only to a certain point, but they can't really take them over and deny them an opportunity to make a profit.
Okay. Bill, let me come down to you on the question. Well, let's say that there is a mandate and the so-called guaranteed issue that Blue Cross is required to issue and cannot use pre-existing conditions as an underwriting criterion. So and that each individual, which is how I understand the idea is presented, that each individual can choose not to participate in the insurance industry. The question I want to pose is, what happens to your company? What happens to the insurance market? The theory says it would be in a death spiral. And I want to, as a practical matter, I want to ask that question. And I want to give you a moment. I'll filibuster for you for a second, because the idea that there are no restraints upon carriers to use pre-existing conditions is actually wrong. The legislation that was mentioned by, I guess by Bill, the Caspam-Kennedy legislation, does have restraints upon using pre-existing conditions, but it's a brilliant law, really, that was across the aisle, bipartisan law, passed in 1996, where a carrier, an employer, a health plan cannot use pre-existing conditions, provided that the person has been in the system, so that you can't game the system. The problem here is that this applies in the individual market, which allows gaming the system. And so I would just like to ask, how would Blue Cross cope with the gaming problem? Why wouldn't Vanderbilt automatically just cease its insurance coverage and then sign faculty up and staff up when they get sick?
Well, it's an excellent question, and one we've been struggling with as you go through the premonitions and all of these plans. Let's talk about pre-existing condition, and so you understand what that is. Basically, it's primarily in the individual market, not in the group market, where an individual comes in and they've got a condition that they know about, and it impacts the rate that they're going to have to pay on the individual policy. Now, remember, our individual rates, we can't just set them nilly-willy. Actually, the state insurance commissioner looks at those rates and approves them based on formulas set forth in the statute today. And across BlueShield of Tennessee, even though this pre-existing condition gets a lot of play, particularly out in California, what we generally do is we have 180 days, basically. If you misrepresent on your policy and tell us that you didn't have a condition that allowed us to write the policy, then for 180 days, if we find out and you file claims on it, then we can go back in. And we don't get rid of the policy, we just put a rider on it to exempt out that condition. But in answer to your question, Professor Blumstein, if you get rid of pre-existing condition, the price of insurance goes up for everyone. Our dilemma becomes, the cherry picking that occurs, because you've got, in one of these plans, you've got this national exchange out there, and if all the good risk rolls over into that national exchange, or if a group decides, well, I'm not going to write someone who's a bad risk, I'm going to keep all my good risk, then either the group or us as an insurer ends up with all the bad risk, and the premiums are so high no one can afford them. And so that's where you hear about the death spiral for the insurance companies. Now, I will say that
Is that intended by some sponsors?
perhaps. I think it's a way of getting to universal health care. But I'm also an optimist in that, I tell my boss this, she doesn't believe it, but if you look at government-run programs, from the post office to Medicare to Medicaid, name any government-run program at the federal level you want to, they generally are not run very well, and they're fairly easy to compete against. I mean, the post office service, FedEx and UPS do a good job competing against them for a number of reasons. So if we're allowed to compete with these federal exchanges, my guess at the end of the day is we're going to find a product that's more lean and mean and does better. The question is, are we going to be allowed to compete? And some of these bills probably would not let us do that. Going to Todd's point, some of these bills really are designed to ensure that the next step is universal health care.